now in session. Please be seated.
Good morning.
Good morning, Chief Justice, Justices. The Attorney General of British Columbia intervenes in this reference in support of the constitutionality of the Federal Greenhouse Gas Pollution Pricing Act. And we do that out of a fundamental conviction that the basic principles of Canadian federalism leave the Canadian people room through their elected representatives to address the global crisis of climate change. And we come to that conviction out of experience, because that experience teaches us both the importance of provincial autonomy and the need for federal leadership. Provincial autonomy is crucial so that each jurisdiction can innovate, find new ways that work for them to address how to mitigate and adapt to the problem of climate change. And British Columbia used the authority that it has under the Canadian Constitution in 2008 to bring in the first comprehensive carbon price in North America. And as a result of that experience, which has been widely studied, we can say that it has been effective. It has reduced greenhouse gases, according to the record before you. The emissions in British Columbia are between 5 and 15% less than they would otherwise have been, but for that policy. And at the same time, our experience also shows us the limits of what provincial action on its own can do. Because we have also had the experience of having the interior forest industry devastated by the effect of the mountain pine beetle. That led to a majority of the merchantable timber in the interior ceasing to be merchantable. And it is directly attributable to climate change, because the pine beetle, before the winters stopped being so cold, was endemic. And as a result of a series of winters where it never got as cold as it did historically, it became an epidemic. And that story just shows us that our actions can have effects if other jurisdictions follow suit. They don't need to do what we did. If they choose other policies, such as a cap and trade system that work for them, then we can, then that's fine. Perhaps we learn from them, perhaps they learn from us, perhaps each jurisdiction decides what works best for its own residents. But what makes this policy issue fundamentally different from healthcare or education, or for that matter, ambient air quality and intra-provincial pollution generally, what makes it fundamentally different is that the inaction in one jurisdiction affects the residents of other jurisdictions. And that's a problem, in this case, that affects the whole world. And the world doesn't have a constitutional solution to that because there is no world government. But Canada is not simply a treaty arrangement between independent states. Canada is a federation with two levels of government, each of which are coordinate sovereigns. And the legislative authority that the British Parliament had to make or unmake any law whatsoever was exhaustively distributed between those two levels of government by sections 91 and 92 of the Constitution Act, 1867. And so the principle that comes from that is that what the provinces can't do, because they're not matters of property and civil rights in the province, they're not otherwise within provincial jurisdiction, and things that are not enumerated powers by within Section 91, the opening words of Section 91 gives Parliament the authority to make laws in relation to those classes of subject matters. What the jurisprudence teaches us is that that power has to be looked at carefully and cautiously to ensure that the Federation remains in balance. But it also teaches us that that jurisdiction is crucial so that between the two of them, Parliament and legislatures can make or unmake the laws that the people of Canada want them to make. And so the Crown-Zellerbach case and the test there is really just the way that the courts eventually, through experience, came to operationalize those two competing principles. And there's two questions, I think, that I'm going to focus on in my submissions today. And the first is whether the matter, this class of subject matter, the matter that is allocated to the federal government by the National Concern Dimension Doctrine in relation to greenhouse gases, can that matter be defined so that there are ascertainable and reasonable limits that ensure the impact on provincial jurisdiction is consistent with the overall balance? And what we say is yes, that the federal government must be responsible for the total national emissions, what we've called the greenhouse gas budget, the national greenhouse gas budget. It must have responsibility for that because no province can have responsibility for that. And it must have responsibility for the intranational allocation of that budget. It must be able to set a principle on which the cost of meeting that is allocated across the country. But it does not have powers over the intra-provincial allocation of greenhouse gas emissions within the terms of that principle.
Intra or
intra? Yeah, intra. So each province has to have the authority to decide within its own industries or within its own consumption rates how it's going to allocate what's been allocated to it by the federal government. Now, setting it in those terms, the question arises why those reasonable limits, why is pricing something that the federal government has the authority to require? And that will be the balance of my submissions beyond that point. But fundamentally, it's because requiring an adequately stringent level of pricing is a legitimate policy choice for Parliament as to how to allocate the cost of addressing the global problem. And I'll get into that. I think that may at first sound counterintuitive, but fundamentally the point is that you could have one way you could do it is say, well, whatever your emissions in 2005 were, everybody has to reduce them by 30%. And that sounds simple, and it would result in Canada, of course, meeting its 30% reductions by 2005. But it would have very, very different implications for different provinces depending on the cost of that mitigation in those different provinces. So provinces that where a major source of emission, as was the case in Ontario, was coal-powered electricity, could change to some other form of electricity, carbon, nuclear, or hydro. And that's not costless, but compared to a province whose fundamental economy is based on fossil fuels, it's a much lower cost way of abating that. And so essentially what the provinces and federal government, with one exception, all the provinces, all the territories, and all the federal government agreed to do was to allocate the burden by requiring everyone to set a price and by saying that the revenues from those prices would be recycled in the jurisdiction from which they were taken. And that has fundamentally different consequences than saying everybody reduced by 30%, because the economic benefit and the economic cost are linked in the same province, and because the economic cost per unit of reduction is the same across the country. And all I have to persuade you is that was a legitimate choice for Parliament to make. I don't think I have to persuade you it was the right choice for Parliament to make, but it was a choice. It had to make a choice in order to allocate the overall contribution that Canada could make to the world's greenhouse gases, and this was a legitimate choice for it to make. And the fact that it could make that choice does not mean it can make any choice. There remain things that only provinces can do. So that's it, so the basic structure of what we are proposing is set out at page 12 and 13 of our factum. I'll just ask the court to turn to that. So there's been some discussion about the naming of the matter that is allocated to the federal government as a result of the national concern dimensions. We've accepted the name proposed by the Attorney General of Canada, the cumulative dimensions of greenhouse gases. I don't think too much should turn on the name of it, because what really matters is saying, what does it mean? And this court is going to have to explain that, and that will provide guidance for Parliament and legislatures going forward. And so what we've broken the cumulative dimensions down into, and this is where maybe our analysis is a bit different than the federal government, we've broken it down into two fundamental components. The first is what we've called the national greenhouse gas budget. And this involves either setting the total maximum emissions from Canada as a whole, or equivalently, a minimum value for the right to add to that total. That's a way of saying this, that a minimum price and a maximum quantity are fundamentally the same thing. That's a basic law of economics, the law of demand. And we have lots of policy areas where we do this the other way around. So, for example, in agricultural products, what essentially Canada does is it sets a maximum total of, for example, chickens that the country is going to produce. And then the federal government, through federal provincial agreement, allocates that to each of the provinces. And then the provinces set rules for how that's allocated among chicken farmers. And so the purpose of setting a maximum amount in that case is essentially to provide income security for farmers. It's to make sure there's a minimum price, not a specific minimum price, but that the prices are kept so that chicken farmers can get an adequate living from the perspective of the policymakers. Setting a minimum price for carbon is exactly the same, but the other way around. So the point of setting a minimum price for carbon is that given the law of demand, that will produce a maximum amount. And so it's really the same thing. There are subtle differences in the ways that that would impact, and some of that literature is in the record. And I'm not going to try to get into the subtleties here, but those are essentially the same thing. It's a policy question for Parliament. Is it going to set a minimum amount, value, price, or is it going to set a maximum quantity? The point, from the point of view of the matter, is it's the same thing, and we've tried to call that the budget. So it's a neutral between whether it's a price or a quantity. But having set a budget for the country as a whole is not going to be enough in a federation. There has to be a principle by which that budget is allocated across the country, the provinces and territories. And in terms of the definition of the matter, Parliament now has an approach. Future Parliament may have a different approach. But the point is that whatever approach is taken, that is something that must be within national jurisdiction. It's obviously something that no province itself can do. It's obviously something where the province's interests are in conflict. The point I've tried to make here is there are multiple ways that allocation could be done, in principle. It could be done per capita. You could say for every resident, X tons of carbon can be emitted. It could be done based on historic amounts. This is essentially what Ontario has been advocating for, saying, well, in 2005, this was our amount, we're down by 22%. Why are we having to take a bigger burden than that? And that would be within Parliament's jurisdiction to take that approach. But that wasn't the approach that was taken, and in part it wasn't taken because the impact on provinces where it would be more costly to abate would be quite significant. And so a third approach would be to say, everybody has to price. That price needs to be of adequate stringency. And someone's going to have to judge that, and the factors that are involved in there have to be set out in some sort of legislation.
What is BC's price under the Federal Act?
Well, we have our own price. It just increased on April 1st, and I'm just worried I'm going to get it wrong, but I think I know, but I'm just worried I'm going to get it wrong. So it's certainly it's ahead of the federal price, and in many ways, at least part
It's more
one.
than 4 cents a liter?
Oh, yes, it is. Yes. So it's done per ton of carbon, and that's turned into fuel charges. Very similar to Part 1 of the Greenhouse Gas Pollution Pricing Act. It's very similar in structure to Part 1.
But BC people with cars are paying a GHG price per liter at the pumps?
Yes, and have been since 2008.
And it's more than 4 cents?
Yes.
Roughly what is it? Take a guess.
I wish I don't want to do that.
So someone's got their hand up. 9 cents? Okay.
I appreciate my comment, Diane. So yeah, so BC, so the way it works right now is BC is not a listed jurisdiction because its price is higher than the federal amount, and Quebec has a different approach, which is the cap and trade approach, and as did Ontario until the government until the new government was elected. So